Mr. Speaker, I rise in this House today to speak against Bill C-246, the so-called Modernizing Animal Protections Act. I'm very proud to represent the vast rural constituency of Dauphin Swan River, Neepawa in west central Manitoba. My riding is primarily agricultural, and in addition to producing grains and oilseeds, the land supports thriving cattle and hog industries. My constituency is also blessed with vast tracts of natural habitats and numerous lakes that support hunting, angling, and trapping activities that are critical to our way of life and our thriving tourism industry. The wise use of our fish and wildlife resources and the efficient, humane, and environmentally sound raising of livestock are critical to maintaining the economy and the way of life in my riding. And it is my duty as MP to vigorously defend our way of life against the ill-conceived Bill C-246. Let me be very clear, Mr. Speaker. We all support animal welfare, but animal welfare is a far cry from animal rights. Canada has good animal welfare legislation at both the provincial and federal levels. However, Bill C-246 is a Trojan horse that would advance a pure animal rights agenda. And Mr. Speaker, the animal rights movement is very clear that their primary goal is the elimination of all animal use. Animal Justice Canada strongly supports Bill C-246, and they are, and I'm quoting, quote, working to enshrine meaningful animal rights in Canadian law, including the right of animals to have their interests represented in court and the guarantee of rights and freedoms that make life worth living. The group PETA on the masthead of their website proudly state that, quote, animals are not ours to kill, eat, wear, experiment upon, or exploit for entertainment, unquote. And then there's PETA's famous line, quote, when it comes to pain, love, joy, loneliness, a rat is a pig, is a dog, is a boy, unquote. There are many other animal rights groups who are advancing the same agenda and strongly supporting Bill C-246. You are known by the company you keep. The Criminal Code of Canada and all provinces have comprehensive provisions that criminalize various kinds of animal cruelty and neglect. The courts have for decades consistently interpreted these provisions as not intending to forbid conduct that is socially acceptable or otherwise authorized by law, such as hunting, fishing, medical research, and slaughter for food. So what does Bill C-246 change? And I'm looking at the criminal code side. I'm not looking at the cat and dog fur or the shark finning. 1, offenses against animals would no longer be offenses against certain property. This significant change takes animal cruelty offenses out of the section dealing with offenses against certain property and moves to the section of the criminal code dealing with offenses against persons, giving rise to the suggestion that animals are no longer a special type of property but are potentially entitled to rights similar to persons. 2, inclusions of the new recklessly test. The new section 182.1 includes the test of recklessly to the existing willfully test for causing unnecessary pain, suffering, or injury to an animal. This expands the kind of conduct that could be criminalized. 3, new kills an animal offenses. The bill adds 2 new offenses that are not currently in the criminal code. 182.21 says everyone commits an offense who willfully or recklessly B, kills an animal, or being the owner, permits an animal to be killed brutally or viciously, regardless of whether the animal dies immediately. Kills an animal without lawful excuse. This brutally or viciously test is completely novel and does not appear to have been previously used in any Canadian statute or interpreted in any Canadian court. And this provision does not appear to exist in any legislation in the United Kingdom, Australia, or the United States. It creates a new and very broad offense. For example, would the current method of cooking lobster by placing them alive in a pot of boiling water be criminalized? Currently, killing an animal is not the focus of the criminal code. Cruelty, not killing, was the focus of the offenses. This new test forces the court to evaluate the method of killing chosen, and if it falls within the test or there is no lawful excuse, criminalizes the behavior. Lawful excuse is not defined in C-246. These 2 sections, depending on how they would be interpreted by the courts, could have the effect of criminalizing many recreational, agricultural, commercial, scientific activities such as medical research and religious practices such as kosher or halal butchering. 4, addition of negligence standard. This widening of the test for criminalizing from willfully under the current section to the much lower negligently test in the new bill can have the potential of criminalizing far more types of behavior. And it must be noted that anyone convicted under the expanded provisions will now have a criminal record that will follow them for the rest of their lives affecting international travel and employment prospects. A person will no longer have to be willfully cruel to be criminalized, just clumsy, incompetent, or unlucky. For example, this section could create consequences for accidentally striking an animal with a vehicle. This is a vast expansion of criminal liability to areas of activity that should not be affected by the criminal law or are already regulated under other existing federal provincial legislation. 5, no specific exemptions for legal conduct to offences listed. The bill in 182.5 that common law defenses in section 8.3 and 4292 of the criminal code are not affected, but these are defenses to the commission of the offence, not the exclusion of otherwise legal activities from being criminalized under the criminal code. These specific legal activities, ranching, hunting, fishing, trapping, medical research, etc., should be clearly listed in the bill so that otherwise legal activities should be taken out of the criminal code completely and not criminalized. And there are also possible constitutional issues, Mr. Speaker. All provinces have animal cruelty laws. I've read every single one of them. Where a federal bill criminalizes an activity that is deemed lawful and regulated under provincial law, constitutional issues relating to the validity of the statutes arise. This is another reason to clearly and specifically spell out which otherwise lawful activities are not criminalized. Mr. Speaker, the criminal code is meant to contain laws that criminalize certain actions or behaviors. It is meant to be broad enough to allow enforcement, but specific enough to target particular actions. The problem with this legislation is that it is not targeting specific actions. We don't actually know what action may be considered criminal with this vague language. It doesn't even provide a list of activities that are permitted. In terms of C-246, many people mistakenly think that this is a rural versus urban issue, or that it is all about hunting, angling, trapping, and ranching. If enacted, C-42 could affect all Canadians. Let's look at medical research. Most, if not all, animal rights groups oppose animal-based medical research. Canadians must realize that most significant medical breakthroughs result from animal-based medical research. Approximately 60% of all cardiovascular research is conducted on animals. The Heart and Stroke Foundation, on their website, notes, quote, remarkable progress has been made tackling cardiovascular disease in Canada over the past 60 years, with death rates declining by more than 75%. This is largely due to research advances. It must be noted, Mr. Speaker, that all surgical techniques are developed and tested on animals before they are applied to humans. Humanity owes a great deal of gratitude to those animals that were sacrificed so that we might live. I and hundreds of thousands of Canadians are alive today because of cardiovascular advancements which were developed using animal experimentation. If we were to stop performing medical research on animals, we're basically saying, let's stop making life-saving medical breakthroughs. This is not acceptable to me or anyone else. Some of these groups want to stop using animals, while others would prefer to push even further and use vexatious litigation to punish those who use animals in any manner. The effect of their campaigns have been devastating for remote rural communities, such as those represented by the current Minister of Fisheries and Oceans, and others that depend on sealing and trapping. And those communities are represented by MPs from all parties here. Mr. Speaker, I do not approve of willful cruelty to animals. However, words are very important, and I fear the language in C-246 will not, in fact, crack down on those who willfully harm animals, but instead put legitimate and necessary animal use practice in jeopardy. I cannot vote in good conscience for legislation that could potentially cast a chill over medical research on animals, potentially criminalize ranchers, trappers, and jeopardize traditional outdoor activities such as hunting, angling, along with the many other legitimate animal use practices that are vital for our economy and well-being. I would ask our colleagues to consider these serious concerns and vote against Bill C-246. Thank you, Mr. Speaker.